Well, good evening, everyone. Thank you for joining our JCU webinar series. My name is Jack Rowden, and I work as the Alumni Relations and Development Coordinator here at JCU. So I'd like to pass on a big thank you to those alumni amongst the audience for joining this session tonight. I do look forward to moderating this webinar. However, before we continue, I wish to acknowledge the Australian Aboriginal and Torres Strait Islander peoples as the first inhabitants of this country and pay my respects to traditional owners and elders, past and present, of the land on which we stand today. In the spirit of reconciliation, I also acknowledge the valuable contribution that Australian Aboriginal and Torres Strait Islander peoples continue to make to James Cook University and the broader community. Now, this webinar is the latest in a series where we invite our top researchers and academics to share their expertise with the local community outside the lecture theatre. Tonight, we will be exploring the legal impact on businesses and jobs of COVID-19. Dr. Louise Floyd is our speaker tonight. However, before I introduce her in earnest, just some housekeeping. If you do have any questions during the presentation, please type them into the Q&A box in your Zoom control panel. Please note, and this is very important, we are not able to give specific legal advice. You're more than welcome to ask general questions. However, tonight's session will be more of a commentary of legal issues stemming from COVID-19. So in the event you have got specific questions relating to your own circumstances, we recommend you consider seeking advice from your own professional advisor. Nonetheless, I will be monitoring the Q&A function throughout the presentation, and I will raise your questions with Louise when and if appropriate. So without further ado, I would like to introduce our sole speaker this evening, Dr. Louise Floyd, who is Associate Professor of Law at James Cook University and a barrister to the Supreme Court of Queensland. She is a lead author of the Cambridge University Press book, Employment, Labour and Industrial Law in Australia, and has held numerous international fellowships, including being the first Australian to be awarded the McCormick Fellowship to the University of Edinburgh Law School, as well as being an international visiting fellow at Cornell University in America's Ivy League. And tonight we are thrilled to have her enlighten us on the legal impact on jobs and businesses of COVID-19. So Louise, I'll pass over to you now. Welcome.
Well, thanks for having me, Jack, and it's a pleasure to be here. For the first slide, it's amazing, you know, you and I were talking about this last week, and at that stage, nobody ever would have believed that we would be starting this seminar on really what's such a sad night when you think about what's going on with Melbourne going back into lockdown. So we both thought that I would be starting this talk by reminding people how bad things were a few months ago with people, you know, fighting over toilet paper. But that's the sad thing. We really don't need that reminder anymore. And I guess for anybody here who's got friends or family in Melbourne, or anybody who's listening from Melbourne, our hearts really do go out to you, because it's no fun being in lockdown with that sort of a health problem facing you. So, you know, we all do hope it works out well.
Absolutely.
But anyway, I guess the great starting point for this talk is to talk about what law's role is in a situation like this. So every night we look at the news and we see Dr. Jeanette Young from Queensland Health doing a great job in such a difficult role, you know, working out clinical issues, working out strategic policy for medicine and how we should, you know, best protect our population from COVID-19. There's an obvious role for lawyers, for medical people. It might not be so obvious what the role of law is, but maybe the best way for us to think about it is to remember what Dwight Eisenhower said when he basically said, the clearest way to see the worth of the law and its role is to think about what would happen if you did not have law. And that's really why originally we were going to start talking about toilet paper at the start of this discussion, because if we do remember back to the terrible toilet paper fights of March of this year, it really was every man for himself. And it was really almost the law of the jungle. And so because people were confronted by panic, they were really worried, and there weren't regulations in place necessarily to deal with every situation as it arose. So the role of law is to try and give order in a pretty chaotic set of circumstances and a novel set of problems. And that's really what a lawyer's role is. It might not be as visible as the medical profession, but it's a really, really important role in trying to give order in a chaotic world and try and give some principles by which people can guide their lives. So that's why with law, I know we're sometimes not the most popular profession, but I would say we do actually, do our bit to make the world a more orderly place. But in terms of the law that we've got, for employment law, it's particularly relevant at a time like this. And I guess some of the people listening to this talk, judging from the questions that we've received, you've lived through just how hard an experience this has been, both for people running businesses, but for people who are employed. So both employers and employees. Now, employment law in Australia, it's always been one of the most robust employment law systems in the world, because right from the very point of foundation of our country, we realised that fairness is important, that logic and order is important in the workplace. So we've always had a pretty sophisticated system of laws right from the get-go. In terms of where we are at the moment with COVID-19, the people who are mentioned on this slide did a great job of assembling at that particular URL a list of all the many, many laws that have been passed since the beginning of COVID-19, and there are tons of them. And they list every topic area, and of course employment that we're zeroing in on tonight. That's one of the biggies. It's very, very important. So for those of you who are interested, you might want to explore that further, after the podcast ends in the days ahead, because it's a very, very good summary of all the many and varied laws that there are. But for our purposes tonight, I'm not going to, sit here and recite the law, but we're going to canvass a few of the issues that it's really useful for people to consider. And as Jack very wisely pointed out, and I'll certainly labour the point till the cows come home, we can't give specific legal advice. And that's not the purpose of tonight. Because if you have got a specific problem, you're really in a position where we recommend you go and see your usual advisor or the relevant regulatory authorities about it. We can't deal with that here, but the hope would be that in raising these issues, that's a very good starting point for all of the people listening to this podcast.
So, Louise, I might just interject there, and just for the benefit of the audience, I will jump in and interrupt Louise at different stages, just to make it a bit more of a conversation.
Yeah.
Talking more generally here, you've got JobKeeper up there, which is probably, when I first seen this presentation, the first thing that I thought, COVID and the law, it's been a scheme that's come out in response to COVID. Yeah. What type of issues arise with JobKeeper? So, I mean, are there people that are taking the scheme for granted and exploiting it? And equally so, are there some people who are missing out altogether? Could you talk a little bit more about that?
Okay, well, I don't want to sort of sit in judgment of people and say that, people are doing the right thing or the wrong thing, but I do know it's a good point that you raise in the sense that there are some really significant legal issues that have arisen with JobKeeper. Now, probably the big one that everybody's heard about is the one that's been traversed in those URLs, those links there, which is the treatment of casuals. And where do casuals square with JobKeeper? So in brief compass, and again, I don't want to, spend a night just reciting the law, but in brief compass, I think most Australians are aware, JobKeeper is meant to step up to the plate at a difficult period of time. The government had this, terrible dilemma to deal with, which is, do we shut down an economy to preserve human life? And obviously that wisely was the choice that they made. But it means also, though, that a lot of businesses are struggling, and it's not their fault, that a lot of employees are looking down the barrel of job loss, and it's not their fault. So the government then stepped up and said, well, we need to do something to deal with these terrible economic consequences of the shutdowns that we've put in place in the hope of preserving human life, because we don't want this virus to spread. So basically, they put in place JobKeeper. Now, the big thing about it is it tries to keep a tether between the employer and the employee. So the employer pays people and then gets reimbursed from the ATO. And the idea is that when we're on the upswing again with employment and there's more activity and people come out of lockdown, and people get their jobs back and their hours back and there is real work to do, that they haven't had an interruption in their employment. Because we know from research that sometimes if people lose their jobs, unfortunately, they'll never get one back. Now, that's exactly where these legal issues you raise come up. So with casuals, because they don't work a full-time job, there is this issue that sometimes a casual, like the figure of JobKeeper is 1,500 a fortnight. There may well be some casuals who didn't actually work sufficient hours to get that normally. So you might say, well, look, is that a bit of a good break for them, that they get more money than they usually get? So the practical issues and the legal issues that have come up are, can an employer ever compel people who are casuals to work more hours to justify that $1,500? And the answer to that is, in a lot of cases, probably not, because you've got to look at what's reasonable in the circumstances. You've got to look at the prevailing enterprise agreements. You've got to look at the prevailing awards. So you've got to go through all of those documents that govern life at your workplace. And you've got to look at that first and say, where does that leave us? But then there's this overarching concept of, is it reasonable to do this? So it may not be reasonable for an employer to demand somebody to do extra hours, in which case they do get paid more. On the flip side of that though, what if an employee, and I think this is really where your question's coming from, what if an employee is thinking, well, this is terrific, I'm going to get a guaranteed $1,500, can I just refuse to work my shifts? And the answer to that in a lot of cases is probably not necessarily at all, because you're still governed by a contract of employment. You've still got to, obey reasonable demands. Hedging all of those things, though, is, for instance, is there anything in your award or agreement that, has actually designated hours? Have you previously agreed to designated hours? So you've got to look at all these variants to know the answer for sure. But at the two extremes, they're the problems, and that's what may well happen, and people may do about it.
Excellent, Louise. Yeah, it's certainly obviously being a scheme that was coupled together in very difficult circumstances. I think we'll probably learn more about those complexities as time goes on. So I'll let you get back into it.
Well, one of the other questions, and this is what you and I were talking about before we started tonight too, that a few members of the audience have raised another issue, which is that of leave and sick leave. And I was sort of saying to you fairly tongue-in-cheek before we started, I'm sure the people who asked that question thought, gosh, surely there must be a simple answer, but there's actually not. So I'm not really being an academic in an ivory tower when I give you a very, very long-winded list of issues to consider. But basically, where sick leave is concerned, again, you've got to look at what are the awards and agreements that govern my particular workplace for a start. So have they got something specific to my workplace that I need to consider? But on top of that, though, there have been federal court decisions, and it may well be that some of them are appealed or some of them might be modified. Furthermore, there's a bit of a difference too between full-time, part-time and casual workers again. Moreover, there's another difference between the type of illness you're dealing with. So since the start of the pandemic, some awards have been actually altered to talk about pandemic leave and unpaid sick leave for pandemic leave. So that's another option that people may have. Now, on that point, if something is, as a general rule of thumb, it may well be the case that if people are stood down and if people have got reduced hours, if they were entitled to sick leave to begin with, it may be that it keeps accruing, but equally it may be that they can't use it for the days that they're told not to work. Moreover, on this distinction between like pandemic leave, the sickness related to coronavirus, and non-coronavirus leave, there is this thing, this unpaid pandemic leave, and it may well be that you could get JobKeeper for that, or you might be able to access paid sick leave for that. So it's very, very tricky. And so what we've done here is we can't answer, and this is why we're saying, and really I'm probably the one who's the dragon lady who's saying, make sure you keep saying we can't give specific advice. We can't, because there are so many variables for your workplace. So these slides that you're seeing at the moment, they're good starting points for working out or introducing this issue of casuals on JobKeeper. tomorrow we're putting up some subsidiary internet links to the Fair Work Ombudsman that talk more about sick leave and JobKeeper. But the really, really important thing is there are so many variables at play. Nobody would be foolhardy enough or arrogant enough to start pronouncing that they knew an answer for a particular person. It's something where you've got to look at your circumstances and seek advice which is relevant to it. But they're some of the things that do arise. One last thing on this as well. Don't forget the rest of employment law still operates here. So things like unfair dismissal, things like adverse action. If you punish somebody in the workplace because they've exercised a workplace right, those laws still apply. So that again, it's a really, really important point to remind people about. So yeah, you're probably thinking, oh, there she goes, another academic in an ivory tower. He's not giving a dead set, straight, simple answer. But that's as good as we can get, actually, Jack, in the circumstances.
Thanks, Louise.
So anyway, continuing on from that, what are some of the other issues that we need to talk about? Well, one of them is structural reform. So one of the really big things to remember about COVID-19, and I guess this is why what's going on with Melbourne at the moment is a really timely reminder of this. This isn't just, yep, it's finished, we'll move on and get back to normal. We're really on the cusp of continued deep-seated change. And when we talk about structural reform in employment and industrial relations, we're really saying, well, look, have the foundations of the way we've worked changed so much that the law actually needs to change to better regulate the situation that we're in. And I think you'll find that the question to that one is a definite yes, that there's been so much change as a result of this pandemic. The change is continuing. And it's a really, really uncertain world that we're in. So the law really has to modify some of its basic planks. So JobKeeper is really aimed at a very specific and very significant issue. But the basic planks of the way we work and the way the law regulates workplaces, that's probably a really big structural issue for us. So Jack.
So Louise, I will just butt in there. We obviously JCU, our main campus, or both our main campuses, Townsville and Cairns, are both in regional Australia. Now, speaking as a JCU staff member to a fellow JCU staff member, we've been working remotely lately. So we have a bit of an interesting question here. What impact might the structural reform of industrial relations law that you've mentioned there have on regional Australia? And so if we're all working remotely, does that open up opportunities perhaps for people to live in regional Australia and work remotely for urban-based businesses, or do you think it could work against regional Australia?
Well, it's another great question, and it's got the potential for both, which is why regional Queensland, in my view, has to really, have faith in itself and really, put forward to government, put forward to the community just how great the regions are and what a crucial role they play in the life of this state and this country. And I'll just pop my cup of tea down here for a minute. But it's really, really, I think, potentially a great opportunity for the regions. Because when you think of the great lifestyle, how wonderful it can be to bring up a young family where there's not congestion and clutter and there's clear air and open spaces and the barrier reef on your doorstep. There are terrific opportunities. Property prices, at the moment, compared to the really big capital cities, they're more affordable. So there are all manner of wonderful, wonderful things about living in regional Queensland. There are all sorts of incredible contributions the regions have made to our state, historically, economically, and at the moment. I think it's a really great opportunity for the regions to stand up and say, well, we've got so much going for us that, if you can afford to sort of live away from where you work, why not actually think about living in the regions? And I dare say, although I'm no sociologist, I think I read recently in either the Fin Review or the Australian, where quite a lot of people who move to the regions are incredibly happy with that choice. Definitely. So that's kind of the first part of the answer to your question. Is there a threat Well, there is, because the danger, of course, is that people get so, obsessed or focused on the big capital cities that then they think, oh, well, let's all move to Sydney or let's all move to Brisbane. And, they forget that living in the regions is great. On top of that, though, the really huge issue here, though, is technology in the workplace. So, there's a whole chapter on my book about robots and artificial intelligence and working remotely and telecommuting. Now, we've had a gradual lean into that in a lot of areas of the economy thus far. Some areas, obviously, even before COVID, had really lapped that up and become, bellwethers for it. But obviously, those sorts of issues about things like, can some jobs be taken over by robots? Are some people at imminent risk of being made redundant? With telecommuting, what are the rules about health and safety if you're working from home? And so for somebody like a lawyer working from home, they would have different considerations from perhaps a scientist. And so there are a really significant number of issues where people have got to say, okay, we've all been telecommuting, but in real terms, what does it mean for tax considerations for working from home? What's deductible and what's not? What does it mean for workplace health and safety if we do this on an ongoing basis? If obviously workplace health and safety is a huge issue for everybody, but are some areas of the economy going to be regulated differently from others? Obviously they will be. And then this nagging issue of, well, if we've adopted technology to such an extent so quickly, does that leave some members of the workforce vulnerable? And if it does, then you've really got to accentuate a discussion which had already begun, which is, well, how do people transition? How do we retrain people? Is it the case, and some of the things that have been mooted previously are things like, on industrial consultative or workplace consultative committees between employers and employees. Could it be the case that, employees, put in for better education so they can be part of change? If it's impossible for people to be a part of that change, then is there some way that, they can at least, even if they won't make it through a complete restructure, is there some way a workplace can be restructured in a way that's less ruthless, that they've got more time to adjust and adjust their finances to look for a new job? So those sorts of conversations and dialogues, they're very important.
Excellent. All right. Well, I'll let you get moving along, Louise.
Okay. Well, that's actually a neat lead in to the very next slide, which is redundancy. So the whole thing is about this, that even though the economy is already beginning to tick up, and so if I've gone to my favourite coffee shops and restaurants recently, I'm sort of thrilled to see that they're doing better than when it was all takeaway. But it won't be the case that everybody will tick up to the same extent that they were previously, because people might tighten their belts, people might be less willing to have that discretionary spend, and also too, as we've just discussed with technology, that might put a question mark over some people's jobs. So redundancy is a big issue. In terms of what does the law have to say for that, again, in awards and enterprise bargains, there'll often be quite a substantial suite of clauses about change, and particularly about consultation in workplace change. So, take advantage of that. Be part of the conversation. Be aware that legally, a job is actually defined as a collection of tasks. So if you are made redundant, but some of your old work is still done, or performed, it doesn't mean necessarily you've got legal recourse, because if the law says, is that complete array of tasks that you did still being done? Qualifications can be a consideration as well, particularly when we're getting to a more tech-based, economy and society and workplace. Other things are, can you be relocated? So things like redeployment, that again is another big conversation for people to think about, participate in. But if you look at the literature to this point, there's actually a surprising amount of really good work that's already been done about change in the economy and change in the workplace, and what that means for workers and employers. And as we were sort of chatting about just a couple of minutes ago, you know, you've got to think to yourself, okay, maybe some jobs will, you know, disappear, but what can we do to try and upskill people to, you know, get different jobs, or maybe to take on these new roles, or for change to be done in such a way that they've got a heads up that they can try and readjust their life so that the worst effects won't be quite as severe and quite as ruthless. So those sorts of fundamental things, they're really important for employers and employees, you know, to have a discussion about. Okay, so some other issues. These books that I'm raising here, they've got very interesting titles. So Snakes in Suits and Taming Toxic People by David Gillespie, who is actually a gentleman that I know. And those books, they were actually, as the title suggests, about dealing with very difficult people in the workplace. Now, why, pray tell, am I raising that specifically now? Well, you can sort of imagine, can't you, that if things get tough in the workplace, if people are worried about their jobs, there can be, you know, quite a lot of ruthlessness in the workplace, perhaps. Some workplaces will absorb it well. Sometimes there'll be a real spirit of camaraderie. But, you know, sometimes human nature being what it is, there can, you know, be a situation where it's quite unpleasant. Equally, though, some employers, you know, when you're in a circumstance like this, where things can look pretty grim, they might be looking for, you know, the proverbial messiah to come out of nowhere to, you know, really build their business up in troubled times. Now, that may be a good idea and it might work, but equally it might not. And so I guess two of the really big issues that's worth us, you know, having a bit of a chat about now, Jack, firstly, what happens with recruitment? So if you're bringing in this new person that you think, wow, they're just what we need in hard times, well, you know, is that always a great thing, or is the law, you know, hovering around in the background saying, just be careful and check? So that's one issue, the recruitment end. But the other thing is about people's conduct in the workplace. So we'll talk about that in a little bit. But just for now, for recruitment, when you read these books like Snakes in Suits and Taming Toxic People, one of the interesting points they make is that it can be a real asset if somebody's changed jobs a fair bit, because they build up a lot of different experience. It shows that they can adjust, and being able to adjust in hard times is probably no bad thing. Equally, sometimes people are really great employees and they change jobs a lot for personal reasons. So if your partner is in the army, they get sent all over the place, and you know, to keep your family together, often people will move with them. So changing jobs, it's not necessarily a bad thing, and it can be a really good thing. But the big but that these guys raise in these books is, just be aware, sometimes though, it could be that somebody can't maintain a relationship, or that they're just not very good at keeping a job. So, you know, that's one of the things that they, you know, just say, be really, really careful that you don't get taken in by somebody and think they're really good, but then you get them and you think, no wonder you changed jobs so much. So I guess the question then is, well, what's the role of the law? And you'd be amazed what a significant role the law has. So this chap here that's in the Courier Mail press clip that I've got up, as the headline says, fake prints costing us a king's ransom. Well, if we scoot on over here, if you ever do want to read this case and read more about it, there's some references on that slide. But as you can kind of get from the photos, this fellow was not all he was cracked up to be. So he actually defrauded Queensland Health of $16 million over a 4-year period. And he lavished people with gifts, and he convinced virtually a lot of a whole city that he was a prince, but he wasn't. He'd actually, I shouldn't laugh, but it really is quite amazing that this happened. He had actually done time in New Zealand, and he also touted his legal qualifications, but he didn't have any. So he eventually, how he pulled it off, if you read the judgment, it goes into it, that he was house sitting for somebody and learned so much about them and their contacts. He took advantage of that for quite some time. Now, he was found out because there was an $11 million transaction, and he bought a $6 million apartment. He bought $636,000 of Louis Vuitton leather goods. And of course, he bought a life-size statue of a horse for the lobby of his home, as one does. So anyway, he got caught out, and anyway, that judgment is about the consequences for him. It's not the only case of CV padding, exaggeration, or sometimes just putting in things that blatantly aren't true. And what I guess the question would be, if times are hard, and if some employers are, desperately searching for this Messiah type figure, could it be that there are other cases of CV padding or exaggeration or fake CVs, and that employers need to watch out for? So
Louise, I might just be leading you in here with a good answer. There's obviously, I'd assume there'd be some employers in our audience. So, in general, speaking generally, what can employers do to avoid being taken down by applicants who embellish and even fake their CV, like the quite bizarre example that you just brought up?
Well, there are two ways of looking at it. One, if you've got caught, but you're actually a lot more optimistic. So I'll skip forward a bit and talk about your question first, which is how do you avoid the problem? And the really big thing is the law loves evidence. So check things. Check people's CVs, check their references. If they're in a different time zone, don't think, oh, I couldn't be bothered waiting up until 11 o'clock to ring up the person, in a different time zone on the other side of the world. I'll just believe what's written down. Well, go that step further and check, because that CV, those references, the claims that they make, that is setting both the employer and the employee up for an employment contract, which is one of the most significant legal relationships most people enter into in their lives. So it's worth the effort to check again. And I say that specifically because, particularly in this day and age, people are sometimes bedazzled, I guess, with, people who say, look at my LinkedIn page, look at my blog I've got, look at this, and it's all on the internet. Now, sometimes that can be great. And if you read books like What Colour is My Parachute, which is one of the all-time classic books about career planning, they say point blank, be aware of your online presence. So an online presence can be a good thing, but just remember, sometimes it's actually the person themselves that's writing all this stuff that's saying, hey, I'm, a world expert at this, that, and the other. Well, if they're saying it about themselves, isn't that even more reason to come back to first principles and say, what's the evidence? Check it out. Make sure it's real qualifications, real references, et cetera. So that sort of rigor is very, very important at the selection process, because again, it really pains to point out, employment, it's a legal relationship. It's a contract of employment. So, if you buy a house, don't you engage a solicitor? Don't you do a building report, a pest report? Don't you check your finances? Don't you make it conditional usually before it's unconditional? Well, this is pretty important stuff too. So why not put that effort in to those checks? So on your very, very good and optimistic question, how do we avoid the problem? They're probably some of the big tips to remember. If we can just backtrack a bit though, if somebody has been caught out, there are remedies. And they range from criminal fraud, unfair dismissal, except it would be perfectly fair, you would assume in some cases, if to dismiss somebody if they've basically got the whole job on a false premise. In some particular areas of work, like the public sector, there'll be codes of conduct as well. So there's quite an array of legal mechanisms in these circumstances if you've been caught out. But as you wisely say, Jack, and it's a great question, you really want to try and avoid the problem rather than look for, a way of remedying a situation after it's gone awry. So if we can continue then, and just on that too, if I can just flip back there, Spring's case I've got there, that's actually a British case, and there's always a big debate about to what extent do Australians, follow some of these British leads. In some circumstances, not necessarily at all, but it actually also canvasses the question, the legal issue of reference writing, and whether there's a legal obligation on those who provide references as well to be, to give due care and diligence in writing that reference. So again, you know, it's easy to sort of like look at a situation that we're in now and think about, yes, we need doctors, yes, we need people who can do IT, but also the law though, it is always in the background, and it has quite a lot of useful issues that it raises for people to turn their mind to. But anyway, on we go. And so workplace bullying. So I mentioned a little while ago that, you know, some workplaces will probably pull together more in hard times, and that's a great thing. But, you know, not every workplace will. Some of them, I would imagine, could become quite, you know, tough. So if at one end, you've got this problem we've just finished discussing, which is what if an employer reaches out to a messiah-like figure, but they turn out to be the messiah with feet of clay. They're not all clapped up to there. But what happens for people who are already there if the workplace becomes really unbearable, that, you know, they turn on each other? Well, the big thing to remember there is there's a legal obligation to avoid workplace bullying and to have a safe workplace. And that's always been the case, that there's been an obligation to have a safe workplace. But what's significant though now is from about 5 or so years ago, the Fair Work Act now has additional anti-bullying laws, particularly for people to try and stop bullying in the workplace. And again, it's like the question you just asked. You want to try and stop a problem rather than just look at remedies for if something's out of control. So that's, again, something to be mindful of, that in hard times, you want to, you know, always remember the human soul of your workplace and the fact that, you know, it's workplace relations, it's relationships between people in a workplace. You don't want them to become toxic. And there are laws to provide a safe workplace, and there are remedies if something, you know, gets becomes a breach of the law. Now, on that point, what are some of the things that, you know, can happen? There's a number of cases that have been decided. This one I've selected. If an employer, you know, might be under stress themselves and might start, you know, criticising people, being overly aggressive, you know, that's not a good thing to do. Likewise, if you exclude somebody from knowledge, so on this thing I was talking about before, that it might get a bit cutthroat in the old workplace. Well, sometimes, what if you know, a boss is even thinking, well, I'm hanging on by a thread. I can think of a few people who are a rung below me who might actually be able to do this job better than I'm doing at the moment. And I'm really scared I'm going to get blamed for things that, you know, go wrong. They might actually start giving people jobs to do, but not telling them everything to do, and virtually set them up to fail by excluding them from knowledge. Or, you know, what if some, you know, employees offer assistance and it's consistently ignored? So there's a number of things in the workplace where you always want to just step back and think, well, we've got to have a safe workplace. But also on top of that, though, there's a lot of people in business who research business who will tell you there's a lot of great research that's been done that a happy workplace is in fact a productive workplace. So those sorts of issues, they're important for people to remember. So other things to think about too. Working from home, we've kind of talked about it a bit already, and most of us have all been doing it for a number of months now. So remember about flexibility. Now, on top of the issues that we've already traversed, which is, you know, to what extent can people continue working from home? Things like workplace health and safety, things like tax ramifications, and the broad sweep of the impact of technology itself on a workplace. Are there other uses for working from home? Well, sometimes if people are kind of, you know, a little bit up against it in the workplace, being able to work from home could be a really good way, a coping mechanism of that. It gets them out of the immediate environment. Now, obviously though, the law wants, you know, businesses to flourish, because if there are no businesses, there are no jobs. So employment law is very much based on the idea that a workplace that's flexible for business and fair for employees is what we want. We want fairness and flexibility. We want both parties to, you know, step up and be a part of things. So we have rights such as in Section 65 of the Fair Work Act for people sometimes to request flexible arrangements. Now, there's a limit on that, at the legal right to request for people largely with, small children and also victims of domestic violence. I've actually made submissions to Royal Commissions that we should expand that capacity to request, because it's only a right to request. The law still encourages people and requires people to have the conversation. Because again, we want fairness and we want flexibility. We want fairness for employees and flexibility for employers. So I've often argued that there actually should be a greater legal right for people to have that request, since it only is a right to request. But a lot of forward-thinking employers, they'll actually sit down and offer people flexibility in some circumstances as well. So that could be a really, really good thing. And some people are more productive. And the final thing is, as we're sort of drawing, I guess, to an end, and we might just have a bit more of a chat about some of these issues generally, Jack, and put a bit more flesh on the bones. But I guess one of the last things I always like to raise in this context, though, is people often speak about teamwork. But I guess my question has always been, well, what actually is teamwork? Is teamwork always being physically at an office from dawn till dusk? Is it having 8,000 meetings, that not all of which might necessarily achieve anything at all? Or is a team player somebody who might be a bit more reserved, who might like to work from home, but they're always there if you need them? They'll never hurt anybody in the workplace, and they'll help them if they need help. It could be that, sometimes we need to think a little bit outside of the box and think, well, what is teamwork? And maybe adding to the fabric of the workplace and workplace relations, could be a really good, place to start. But anyway, so that's, I think, largely a lot of these slides. But
we do have a question here, Louise, from Amanda, and this one goes back to what we were talking about with JobKeeper. So Amanda's just asked, so what about seasonal workers pre-agreement? Not to work particular weeks. Is JobKeeper paid for weeks there was no pre-existing agreement to work those weeks?
Well, again, you'd have to see the Fair Work Ombudsman. And part of the reason is because it's such a specific question, but also things are changing so much. So on these links that we're loading tomorrow to various entries that the Fair Work Ombudsman has got about leave and about JobKeeper, one of the interesting things that only in the last week or two, the Queensland government and also the Victorian government have mooted a government-sponsored scheme for hardship payments. So whereas sick leave you're thinking about, well, is it the employer who pays? They're actually mooting this prospect that you can have a hardship payment from the government if you don't have sick leave to access. So from that point of view, again, these are really great questions, but because this is such an unfolding story, and as Melbourne, is the sad example that things will change on a dime, you've really got to go back to, here's my agreement, talk to the employer. If you're an employer, talk to the employee, be aware of your award, your agreement, but also go back to what Fair Work says. So these links we put on the website tomorrow, they're directing you straight to the Fair Work Ombudsman, who have given you a laundry list of various issues that arise for leave, for casuals. But on top of that, though, they say on a lot of those entries, this is up to date as date X, because they know the situation could change. So to that, what was the questioner's name?
I'll give Amanda. It was Amanda.
So to Amanda, that would be my recommendation to you. Go back to the Fair Work Ombudsman, have your agreements, have your enterprise, agreements and your awards, and talk to them about it, because they'll be able to do what I've got no hope of doing here and no capacity to do, and in fact legally can't do. They can start reading those documents perhaps, or whatever other advisor you've got, be it a union representative and so forth. So I'd strongly recommend have a look at those things as a starting point, but then talk to somebody who is a specific advisor to you, who can actually read the terms and clauses of those very important documents.
So Louise, I think, all of us, either on the panel and participants, everyone in society, we're either employers or employees. So I think something that I've certainly taken away from your presentation, it has been very insightful. So thank you very much. I think it's all about awareness, isn't it? Particularly, you mentioned just probably about 2 or 3 minutes ago, you were talking about the changing landscape, the constantly changing landscape that we live in. Governments cop a lot of flack, but it must be very, very difficult changing the law so rapidly, and also with new challenges that the unique times we find ourselves in certainly bring up. So I think awareness, and perhaps also, would it be fair to say some patience as well between team members and between employees and their employers, as we all try and navigate these difficult times?
Yeah, well, I think that's such a good and a really healthy, positive view of what's going on, Jack, because, see, that is the whole thing. These laws were put in place so quickly, but, the government had no choice but to do things quickly, to try and, as to use their terminology, send lifeboats out to people in extraordinary circumstances for an economic storm nobody could ever have foreseen. So when you look at these things, there are so many issues where time and time again, people will just say, look, we can't give you a definite answer, but we'll push you in this direction. And also people might say, well, why didn't the government think of this? But see, this had to be legislated so quickly, because ultimately, what did they want? They wanted money to get out to people who would otherwise be, well, they're not necessarily in a great position even now, but it would be a lot worse without these sorts of safety nets. And, that's the whole thing, that basically they were, dealt the most terrible choice to make, in terms of, you say, well, look, if we lock down the economy, employers, employees, they will all suffer. And for the most part, it's not their fault. Whereas the flip side of that is, but if we don't, then, this virus is so transmissible. What do we do? Do we think economy? Do we think human life? Can we strike a balance? So with these laws, even the government probably will tell you that, I don't speak for the government, obviously, but, it may well be they even say, yep, it's not 100% perfect. But in an imperfect world, it's a good place to start. But as you say, people have just got to be a bit patient. And a lot of people have already been very patient. So I don't want to sound arrogant to people who have obviously been through, a heck of a lot. But, it's that process of working through things to get to the bottom of it. One thing I would say, though, is, and it's probably a really good way to spend time as this presentation begins to draw to a close, it's a little bit more about the technological aspects of it. And so one of the things, I think that's really, really important is to remember, change in the way we work, this structural reform that we talk about, it's a huge issue that was always going to be there. Now, earlier this year, I went to a breakfast where a gentleman called Andrew Leveris, who'd worked as both an advisor to President Obama and also President Trump, spoke at my old high school, because he went to my old high school. But he was just saying, some of the overseas countries, particularly the United States, they're so attuned to the fact the economy is changing. They're so attuned to the fact that, artificial intelligence is a very real thing that people will use more and more. Telecommuting is a real thing that people will use more and more. That some jobs will be replaced by robots, but others will endure and new jobs will be created. And he was just saying, you cannot underestimate enough the significance of those points. And since we're like a university that's hosting this, we've got to think, and we already do think, we're very mindful of this at JCU, but, in that changing world, graduates are going in to something that some people would, say in some aspects of life is a state of flux. So,
absolutely. Louise, I might just interrupt you there. We do have a question from Michael. So you're talking about, obviously a lot about the momentous times we find ourselves in. They're changing times. And I think, like you're saying, the workplace is going to change permanently, and is always morphing. So a question from Michael, he said, what are the chances of industrial relation reform shifting the balance of power between employers and employees in favour of the latter? And we've only got probably about 2 or 3 minutes to answer this. And would you be able to fill Michael in a little bit there on your thoughts?
Well, I think the aim is, and certainly the theoretical underpinnings of the system as we know it is, try not to have it skewing in one direction or another, but have it centred and have it so that this old adage of fairness for workers and flexibility for employers are mutually enforcing goals. They're not mutually exclusive. And as I said throughout the main part of this talk, there is actually really good research, and a gentleman at Griffith called Professor David Peets has often written about this. A happy workplace actually is a productive workplace. So I guess a lot of employment lawyers would say, if you have really jarring changes in employment law, does it really benefit anyone, or does it actually hurt a lot of people? And so, for instance, the most jarring shift that we've probably seen in the last 10 or 20 years in Australia, it was when we had work choices. So that was like a dramatic change in the way industrial law operated in this country and what the laws were. Now, most of those changes lasted for about, 2 years, and they became so unpopular that the government was voted out of office and the Prime Minister lost his own seat. So what I would say in answer to the questioner's question, do we really want those sorts of extremes where you're thinking, let's swing a pendulum one way or the other? Or is maybe our time best spent thinking fairness and flexibility, fairness to workers, flexibility for employers? They're mutually reinforcing goals. They're not mutually exclusive. A happy workplace is a productive one, and go for the centre. And for all the heartbreak that's come out of this, and when we're reminded tonight on the news of what's going on in Melbourne, and to see poor little kids in these, housing towers that, can't actually even breathe fresh air. They've got no balcony. They're stuck in these, places and can't even run on a lawn for a week, which for a little kid would be terrible. There's so much heartbreak, but to me, the one good thing that one of the things that might come out of this that's good, that people in a national cabinet, that unions with the government of a different political persuasion, they've shown a real appetite for and a capacity to work together. And again, this is why I always find your comments, Jack, really uplifting and very healthy and very positive, that, ultimately, workplace relations law, what is it? Well, it's the law that regulates relations at the workplace, isn't it? That's a big part of it.
Absolutely.
So you've got to think about that idea of let's work together. And that would certainly be my hope, that when we have structural reform, which is absolutely necessary, that we all sit around a table and say, rather than having these jarring extremes, can we put in place a system that will endure, so that, our graduates of this great university, that, the people listening who might be, in this position themselves or have kids that are looking into the future, they've got some certainty that comes out of all this uncertainty. And but if I can just say too, to be a bit optimistic myself, sometimes there have even been papers that have questioned, the relevance of the legal profession if there's a lot of technological change. But I'm so upbeat about, our future because as this talk shows tonight, law is always there. It's what really is underpinning all society. It's what gives order out of chaos. It's what gives principle to people in tough circumstances and stops it from being the law of the jungle.
Absolutely, Louise. I think that's we might end on that optimistic note, as we are running out of time.
Yeah.
I would like to really thank you very much. It was a very insightful presentation, given the parameters that we have to operate in speaking on this topic. So thank you for that. And also thank you to everyone in our audience who did tune in tonight. All the best for the times ahead. There certainly are challenging times, but I think, like we concluded there, there's certainly room for optimism in the midst of adversity. So we really would appreciate your feedback so that we can continue to deliver some interesting and engaging webinars throughout the rest of this series. And as such, if you wouldn't mind sparing some time to complete our feedback survey, that would be greatly appreciated. A link should appear once the webinar concludes. The date for our next webinar, as you can see there, is Thursday, the 16th of July, where we have a particularly exciting session exploring stress amongst adolescents with an award-winning author and educator, Maggie Dent. However, for now, I'd like to say thank you very much and good night.
Thank you, Jack. Good night, everybody. Bye-bye.